I'm going to talk a little bit about the U.S. Constitution, obviously the foundation of our system of government, and its role in our history. The first thing I guess we should say is that the Constitution is the oldest Constitution in the world. It was written in 1787, ratified soon after that, and no other country in the world has had a continuous Constitution since that, as long as that. With the possible exception of Great Britain, which claims to have an unwritten constitution, which is simply the accumulation of all the precedents and rulings and everything. But they don't have a written document that you can refer to like the United States. So we have lived under the same constitutional system for over 200 years. On the other hand, the Constitution, of course, has changed significantly over those years. One of the things the Founding Fathers were intelligent enough to do was to realize that the Constitution was not perfect, and certainly that times would change and that the needs of the country would change, and that the Constitution itself might have to change. And so, of course, the Constitution, they put in the provision for amendment, and the Constitution has been amended over 25 times. Some of the amendments fairly trivial, some of them extremely important. The Bill of Rights, added to the Constitution in 1791, lays out our basic civil liberties as Americans. The 13th Amendment, after the Civil War, or at the very end of the Civil War, abolished the institution of slavery. Amendments gave black people the right to vote, gave women the right to vote, provided for the direct election of senators, 18-year-olds the right to vote, and many other changes in the system. So it is a flexible constitution. Amending it is not easy, but it certainly has been done and can be done. Equally interesting, I think, is another aspect of the Constitution's history, which you might call constitutionalism. That is to say, the belief in the American political system and the country at large of the significance of the Constitution, of the necessity of making our political behavior conform to the Constitution. At all points, really, in our history, when controversies arise, as they always do, competing groups tried to ground themselves in the U.S. Constitution. Before the Civil War, both Northerners and Southerners cited the Constitution, claimed they were defending their constitutional rights. Southerners insisted that slavery was protected by the Constitution. Northerners insisted that the Constitution allowed the federal government to prohibit slavery in the Western territories and indeed to take other action against slavery. My main area of scholarship has been the Civil War era, the Reconstruction era after the Civil War. And I've often been struck, even in that greatest crisis in our history, when our problems were resolved by war, not by political bargaining or negotiation, still, even at that time, people tried to conform to the Constitution, or at least to claim that what they were doing was within the bounds of the Constitution, or to change the Constitution so as to put into the Constitution their understanding of the results of the Civil War. So, for example, at the end of the Civil War, the 13th, 14th, and 15th Amendments put into the Constitution the victorious North's understanding of what had been accomplished. That is, that slavery would be forever prohibited. That was the 13th Amendment. Then in 1866, that African Americans would be granted the same basic civil rights as other Americans enjoyed. And finally, the 15th Amendment, which prohibited the states from discriminating in terms of the right to vote on the basis of race, thereby giving black men the right to vote throughout the country. These were added to the Constitution because that was the way to ensure that they would be permanent features of our system. And again, in the debates over Reconstruction, even though the Constitution was not devised to deal with a situation like that, none of the founders envisioned a situation where 11 states would leave the Union and wage war against the nation. That was inconceivable to the founders. And some might say, well, the Constitution really has nothing to do with this situation. But in fact, the Northerners who won the Civil War did not just say, okay, we're victorious, we can do anything we want. They insisted on having what they did conform to a notion of constitutional government, having the Southern states ratify the new constitutional amendments, and as I say, keeping they didn't tear up the old Constitution and write a new one, but they amended it to make it, in some ways, a very different document. Now, let me just go back and mention a few of the fundamental features of the original Constitution and then how it has changed over the last 2 centuries. The Constitution as written in 1787 was fundamentally a structure of government in 2 ways. One, it set up the federal government and the division between the different branches of the national government, the presidency, that is the executive branch, the Congress, the legislative branch, and the judiciary. Although very little was said in the original Constitution about the judiciary, just that there would be a Supreme Court. It didn't quite say what the Supreme Court was supposed to do, and indeed it didn't even say how many people had to be on the Supreme Court. We usually have 9, but not always in American history, and there's nothing in the Constitution to prevent you from having a Supreme Court of 10, 11, 15, whatever number Congress may desire. But basically, the Constitution sets up the rights and powers of these branches of government and the so-called checks among them. They did not want power to be concentrated in the hands of any one part of the government. They were fearful particularly of a monarchy, as we'd had under the British, and power being concentrated there. But they were also fearful of too much power in Congress, which might override the liberties of the people. So balancing off these various branches of government was supposed to prevent any one of them from trampling on the rights of Americans. Then there's the different balance between the state governments and the national government. The Constitution was written because many of the founders felt that the national government was too weak. Under the Articles of Confederation, our original Constitution, the federal government had very little power, and nothing could be done without the unanimous approval of all 13 states, which was often rather hard to get. So a stronger central government with more independence, and particularly the ability to tax and raise money for itself without having to beg the states for money, this was one of the reasons for the writing of the Constitution in the first place. But there's very, very little in the original Constitution about individual American citizens, about their rights. It does talk about the privileges and immunities of citizens without saying what they are. That was added in the Bill of Rights. Many of the people who opposed the Constitution's ratification objected to the absence of Bill of Rights, and very quickly after ratification, Congress passed the first 10 amendments, which are really the foundation of our civil liberties. And the First Amendment guarantees our freedom of speech, freedom of the press, the right to petition the government. Others prohibit, cruel and unusual punishment. They give you the right to a trial by jury. They insist that you cannot be forced to testify against yourself. The right to bear arms is in the Second Amendment. All of these were protected against infringement by Congress. The first words in the Bill of Rights in the First Amendment are, "Congress shall make no law prohibiting the freedom of speech," etc., or interfering with freedom of religion, etc., etc. It didn't apply to the states. The states could do anything they wanted. States could have established religion if they wanted. States could interfere with your freedom of speech, as they often did in that early day. It was to prevent Congress from interfering with these basic liberties. So right from the beginning, the Constitution was amended to expand its impact upon ordinary American citizens. Of course, the Constitution contained within itself the fundamental contradiction of the early part of American history, which is it began with the words, "we the people," and said that its purpose was to secure for the people the blessings of liberty, and yet buried in the Constitution are protections for the institution of slavery. The 3/5 clause giving the South added representation in Congress by counting 3/5 of their slaves, who of course have no political rights. the Fugitive Slave Clause, which says that if a slave escapes from the South, that they have to be returned. It doesn't quite say who is responsible for that, which became a point of dispute. But there are certainly protections for slavery in this Constitution devoted to liberty. Slaves were not considered part of the people of the United States. We, the people, were free, basically free white people in the early days of the Republic. Later on, as I said, of course, the exact relationship of the Constitution to slavery becomes a major focus of political debate, and political parties rise in opposition to each other on this question, and the Civil War then resolves this. And as I've mentioned, to guarantee the results of the Civil War, 3 new amendments are added to the Constitution, 13th, 14th, and 15th. The 14th Amendment fundamentally changed the Constitution and really gave birth to the Constitution we have today, because the purpose of the 14th Amendment was to put in place a new definition of American citizenship, of who is an American and what rights they are entitled to. It said for the first time that anybody born in the United States is a citizen. It doesn't matter where you come from, it doesn't matter where your parents are from, it doesn't even matter if your parents are here legally or illegally. If you are born in the United States, you are a citizen of the United States, and as such you are entitled to full equality before the law. The states, it said, cannot pass laws abridging the equality of American citizens. Notice, the 14th Amendment is to protect our liberties against infringement by the states, not the federal government. And over the 20th century, the Supreme Court has basically applied the Bill of Rights to the state governments. All those liberties protected against federal infringement in the Bill of Rights are now, most of them, to be protected also against states interfering with them. Freedom of speech, freedom of religion, all the criminal procedures you're entitled to if you're accused of a crime. And particularly putting into the Constitution this notion of equality among citizens. There was nothing about that in the original Constitution. The original Constitution does not use the word equal or equality, except in talking about the number of senators that each state has, that is 2, an equal number. The 14th Amendment, in doing that, in a sense, made the Constitution what it is today. That is to say, a document to which groups who feel they are being deprived of their rights can appeal in court, appeal to the courts, appeal to Congress that their constitutional rights are being violated. It turned the Constitution into a vehicle for those who felt they were lacking equal rights in American society, which the original Constitution really could not have been. Subsequently, other changes in the Constitution were made in order to deal with the rise of America as an industrial power, the expansion of the federal government, the need for further revenue, such as the Income Tax Amendment in the early 20th century, which allows the federal government to collect money through an income tax, a much more efficient way of collecting money than previous taxes like the tariff and things like that. But what's interesting in the 20th century, actually, I think, and into the 21st, is unlike the Civil War, our great controversies did not result in basic changes to the Constitution. The New Deal, for example, of Franklin D. Roosevelt changed American government and society in very fundamental ways, but did not change the Constitution. There were no constitutional amendments during the New Deal. What would change was the Supreme Court's interpretation of the Constitution. During the late New Deal, the Supreme Court altered its previous interpretation in order to allow the government to engage in economic regulation, economic activity, which previously had been barred as violations of the right of property. But of course, there is an old saying, the Constitution is what the Supreme Court says it is, and of course the Supreme Court has become the final arbiter of what constitutional language means. Similarly, the civil rights movement of the 1960s, which fundamentally changed American society, did not change the Constitution. There was one amendment which outlawed poll taxes, that is, laws requiring you to pay a tax to vote, but that was a fairly minor thing. What the civil rights movement was demanding was that the Constitution actually be enforced, that the 13th, 14th, and 15th Amendments added after the Civil War and still in the Constitution, even though flagrantly violated in much of the South, that the government should now actually enforce these measures. So in a sense, they were asking to really live under the Constitution that was on the books, not the one that was being violated frequently in many parts of the country. So unlike, for example, in South Africa, where the end of the apartheid regime in the 1990s led to the writing of a new constitution, the civil rights movement did not want a new constitution. They wanted the old constitution enforced by the federal government, which it had failed to do for many, many decades. So the Constitution is, as we say, it's an old document, but it's also a new document in the sense that it is a living document, and how it is interpreted changes over time, and our rights have expanded enormously since the 1960s without fundamental changes in the Constitution, but changes in society have been reflected in our understanding of the Constitution. One other example is the right to privacy, something that most Americans take very seriously now. The word privacy is not mentioned in the Constitution, but starting in the 1960s, the Supreme Court established a constitutional right to privacy, that they said within the Bill of Rights, that the various rules and regulations and liberties in the Bill of Rights add up to a basic right of privacy that the government cannot infringe on, even though the word is not mentioned in the Constitution. So the court kind of expanded how they understood the old language of the Constitution to meet the needs and demands of the modern day. So, as I said, we're still under the same Constitution with amendments. On the other hand, as long as Americans are debating political and social questions among themselves, we will disagree as to the exact meaning of constitutional language and how the Constitution applies to our society today over 2 centuries since it was actually adopted. So thank you for listening.